The Los Angeles Police Department shot the family's golden doodle, a Knicks fan named Jameson, who was still wearing his jersey during the Knicks championship celebration. My name is Tim Scott. I'm a civil rights trial attorney, and my colleagues and I here at Mackenzie Scott are the Justice for Daisy's attorney. We had the honor of representing the Cerna family out in San Bernardino, where a similarly horrific event just occurred in May of this year. Let me walk you through the legal landscape, because it's the same one that's about to unfold in Justice for Daisy. What are Jameson's family's rights? Well, let's start at the front door. If the officers crossed into the home, or even the area around the home, what we call the curtilage, without a warrant, that's a Fourth Amendment violation from the moment it happens, unless one of a few narrow exceptions to the warrant rule applies. The Supreme Court says that the home is first among equals when it comes to constitutional protections. And importantly, if the police gained entry into the home by banging on the door and saying, "Police, open the door," that is not a consensual encounter. That's actually a search under a case called Bautista that I litigated years ago when I was a federal public defender. So now here's the real move. Even if the dog shooting looked justified in that split second, the family can recover if it is the fruit or the natural consequence of an unlawful entry. The Ninth Circuit said exactly that last year. You don't get to create the danger and then hide behind the exigency of the situation that you as a law enforcement officer just created. Now, separately, killing a family dog is itself a seizure under the Fourth Amendment. When officers already know that the dog is there, but they don't have a plan for how to deal with it, then that can be unreasonable if the officers end up killing a dog just because they didn't have a plan for how to handle it. There's a case called Hell's Angels that says exactly that as well. So these are all federal claims, but California law adds on. There's a law called the Bain Act, which is a state civil rights statute that provides for triple the damages plus attorney's fees, and you don't have to deal with the prospect of qualified immunity under the Bain Act. Importantly, in California, and this is true under federal law also, a dog is not just property. The damages aren't just the economic value of an animal. Here, the family could recover for the emotional trauma of losing that loved one, plus punitive damages if this was an intentional act, which perhaps it was. Does that roadmap sound detailed? Well, it is, and that's because we're litigating this exact analysis for Daisy out in San Bernardino County. Sadly, Jameson and Daisy doesn't seem to be isolated events. This is a pattern, and it's something that we here at Mackenzie Scott are hoping to stop.